Good morning, this is Melanie Daly here with your Daily Grind with a morning cup of coffee to talk about another workers' compensation issue. Today we are going to talk about one of my favorites, which is labor market attachment. As you know, when a claimant is deemed to be partially disabled, there is a requirement that he or she attaches to the labor market, essentially looks for work or a training program that shows that they are trying to get back into the market and actually get a job, and that entitles them to benefits. So essentially, we typically will raise the issue at the hearing, and then we will request a direction for same within 45 days and then 45 days thereafter, or sometimes it's 60 days, but we try to keep it 45. And we monitor the file to see what the claimant uploads, and a lot of times it can be interesting to see what we find. So when you get your evidence of labor market attachment, it really should be scrutinized to see what the claimant's actually doing. Under American Axle, which is a board panel decision which discusses the requirements of labor market attachment, the claimant must make diligent, persistent, really real attempts to attach to the labor market, actually looking for a job. A lot of times claimants will write down, the first name, no contact information of somebody at an employer, but will not provide any specific details. They do have specific requirements in the decision that says if the claimant goes in person, you should record, he has to provide the name that he spoke to, the point of contact that he made there, what occurred at that point of contact, whether he attempted to follow up afterwards, whether he was offered a job, whether he was advised that he wasn't getting a job. And a lot of times the claimants, they don't provide that information. So essentially it's really important to, look at the actual attempts, because they can make it look very good and legitimate on paper, but when you actually look to see what he actually did, it's not so good. For example, I had one claimant who essentially spent his days driving around to people that he knew who owned businesses to see if they were hiring. And there is actual case law that says that is not sufficient, especially because he didn't even apply for any jobs. He had no knowledge whether or not these employers were actually hiring. He was just going there to see if they were, and he would write it down. But that's not sufficient. You should be looking to see, and nowadays everything's typically online, but looking for local businesses that do actually have openings that he qualifies for and that is within his restrictions, to see whether or not he can get a job. And my favorite scenario in there was that he was originally a driver, and then when he was injured, he was, claiming that he couldn't drive anymore. But then how did you spend your entire day driving from business to business asking if they were hiring? Just an interesting side note. But essentially, when you get your labor market attachment evidence, you really should be looking it over. A lot of times we even press the issue, if there is a direction within 45 days, that awards should be suspended as of the date that labor market evidence was due, because there is a third department decision that does indicate that the power and authority of a workers' compensation law judge to direct something should be followed. If it's not followed and that's ignored, then we really should be pressing that issue about the fact that, he just disregarded the direction to provide labor market attachment and nothing's done about it. Typically, law judges will not suspend on that basis, but that's something that we always like to push. However, another point about labor market attachment is that it can also be used when you are going to interview or take the testimony of the claimant on the matter of LWAC, loss of wage earning capacity, because if he's applying for these jobs, that can really be used as a good tool to see, well, what kind of qualifications do you have? If they're essentially portraying that they have a list of qualifications that they actually don't in their job applications, which means they know they weren't going to get that job anyway, then they can't really be deemed attached to the labor market. That's just another side argument. However, We recommend when you get that direction, you monitor the file, you file the RFA if it's not filed timely, and you take that claimant's testimony on what he actually did to look for work. Because a lot of times, what you see on paper is not sufficient to establish attachment. So if you have any questions on attachment, of course, please feel free to reach out to us. If you have any other topic that you are interested in over your morning cup of coffee, we would love to hear from you and we will have it covered. Thank you. Have a good day.